You know, an aphorism often attributed to Thomas Jefferson, but which was widely used in the early 1800s, reads, "Eternal vigilance is the price of liberty." And a case just heard by the Supreme Court on Monday reaffirms the truth of that dictum. This one is about the right of self-defense. It's the first big gun rights case to be heard in over 10 years, and it is extremely important to watch. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and let's dive right into this one and get some information we can take with us. The case just heard in oral arguments is called New York State Rifle and Pistol Association Incorporated et al. Versus New York City, New York et al. And it reveals an incredible infringement of the right to keep and bear arms. And it's important and revealing not just about how every level of government chips away at basic human rights, but also how certain Supreme Court justices exhibit some striking lapses in cordiality in this particular case. Now, here's the layout. Until a few months ago, New York City allowed very limited, restricted, licensed ownership of firearms, making them practically serviceable only in one's home. And it prohibited the transport of licensed guns outside the city, which, as folks familiar with the concept of rights and the U.S. Constitution know, is a big no-no for any political body. So, the plaintiffs, numerous New York City residents working with the New York Rifle and Pistol Association, brought suit. And throughout 2018, they got shot down, first in the federal district court and after that in the Second Court of Appeals on the federal level. So they kept fighting, and they got their case accepted by the Supreme Court last January. And what's interesting about that is it appears to have lit a fire under the politicians in New York City and New York State, as Amy Howe writes for SCOTUS blog. The announcement was significant because the SCOTUS Supreme Court justices had not taken on a Second Amendment case for nearly a decade. But over the summer, the city urged the justices to dismiss the case before it could be argued, explaining that because it had repealed the ban and the state had changed its laws, the gun owners had received everything that they had asked for. The justices declined to do so, instead setting the case for oral argument today. So, what did we have prior to the changes from New York City and New York State? We had a municipality infringing on the right of folks to keep and bear arms inside and outside the city limits, inviting unwarranted searches of city residents who might be suspected of returning to the city after taking their guns beyond the city proper. And the city would be deterring city gun owners from training with those arms, something that the Big Apple politicians actually require in order for residents to renew their so-called licenses. You want to train with a gun in some facility outside of New York City? Well, until the city code was changed, residents had to rent guns because they were forbidden from taking their own to the practice facility. Said lead attorney for the plaintiffs, Paul Clement, text, history, and traditions all make clear that New York City's restrictive premises license and accompanying transport ban are unconstitutional. The city's restriction on transporting firearms to places where they may be lawfully possessed, and its insistence in its revised regulations that any such transport be continuous and uninterrupted are premised on a view of the Second Amendment as a homebound right, with any ability to venture beyond the curtilage with a firearm, even locked and unloaded, a matter of government grace. That view is inconsistent with the text, history, tradition, and this court's cases. And Clement added another important point. And there is no historical analog for the city's prohibition in transporting firearms to places where they may be lawfully used. To the contrary, the Second Congress required the militia members to take their own firearms from their homes to the training grounds. But mere seconds into his opening statement, Clement was unceremoniously interrupted by leftist Ruth Bader Ginsburg, who argued that the case was moot because the city changed its code and the state passed a law allowing transport. So what's left of this case? The petitioners have gotten all the relief they sought. They can carry a gun to a second home. They can carry it to a fire, to practice at a range out of state, which not only shows Ginsburg's lack of civility in that instance, it shows a lack of understanding of the rights violations committed by the city. So, Clement noted important points that she seemed to miss. First, he explained that if the state had not passed its law and New York City still had its prohibition on the books, he and his clients would have sought a ruling in court that the city ban is and always was unconstitutional, which would act as a prophylactic against future governments trying to reestablish such a ban. And Clement added this: but we would also be entitled to an injunction that did three things. 1, prohibit future enforcement of the transport ban. 2, prevent the city from taking past conduct in violation of the ban into account in licensing decisions. And 3rd, an injunction that would safeguard our right to transport meaningfully such that it wouldn't be limited to continuous and uninterrupted transport. And despite additional interruptions by Ginsburg and leftist Justice Sotomayor, those last 2 points stand as very important. How is the government granting New York City residents permission to take their firearms outside the city, consistent with the untouchable fundamental right to keep and bear arms? It is a right, and it is not supposed to be touched by any government law. To make matters worse, this permission is contingent on owners transporting them continuously and uninterrupted. You need gas while taking your gun outside of New York City? You want to stop for coffee? Well, good luck. And of course, it still leaves residents open to arbitrary, unwarranted searches. Now, Sotomayor argued that the rule on continuous transport should be argued in a different lawsuit. But Clement noted that if the lower courts had allowed them their injunctive relief, the plaintiffs would never have agreed to any form of a mandate regarding transport being continuous. Moreover, Clements pointed out that those who have violated the original city prohibition against any transport outside New York City can now be denied a license on the basis of those previous strikes. Now, interruptions aside, this New York State Rifle and Pistol Association case is important for more than what it reveals about the civility or lack thereof of the justices. Heck, even the supposedly conservative Chief Justice John Roberts appears inclined to dismiss this important case. It also sheds light on the depths to which politicians at every level will stoop to crush the right to self-defense and how we can't rely on the Supreme Court to protect our rights. In fact, if we go back 10 years to the last big gun case, we have to remember Antonin Scalia, a hero for many, actually ruled in the Heller case in 2008 that although the Second Amendment protected the right to keep and bear arms as an individual right, he added that rights can be attenuated, completely undercutting the entire definition of the word rights. So the lesson here is we need to watch this case out of New York, and we need to keep in mind that we can't just rely on those black-robed figures in Washington, D.C. to protect our rights. As the dictum says, we need to have eternal vigilance and talk to each other about these things. Teach our kids, talk to our neighbors, ask them their opinions, and inform them of some of this information. Share the videos, and don't forget to like and subscribe. Perfect segue to mention, if you're watching on YouTube, hit the little bell because it's supposed to tell you when videos come out, and head on over to MRCTV.org because there's always something new happening there. Hey, thanks so much for spending this time with me, everybody. For MRC TV, I'm Gardner Goldsmith.